concern, or I want to pose a concern about a contradiction that I see between the statements that you both have made in a way, saying that the current model does protect the right of governments to regulate to a certain extent, at least insofar governments legislate for legitimate purposes of public concern. But we just have seen that Philip Morris has sued the government of Uruguay when Uruguay tried to implement new policy that would increase the warnings in the cigarette packages. They're using the Switzerland-Uruguay bit for it. So, I mean, I'm just thinking if public health is not an absolute minimum public concern, that, you know, and it's a legitimate concern, and governments should have the right to regulate in to protect public health, what is it? So if the Uruguayan government can be sued for such a type of regulation, we're not talking about expropriating companies, we're not talking about, you know, other type of measures that could be more contested. This is clearly a legitimate regulation to protect public concern. So I see this discrepancy between your declarations and statements that the rights to regulate of governments is protected, when we are seeing just now these companies suing governments using the model that the European member states follow, and can really, you know, sue legitimate regulations from southern governments. So maybe if you can comment on that discrepancy.
Has an award already published, decided on this issue? But that's the point. The idea, we want to avoid any discriminatory treatment of the investors, but we cannot prevent in advance that a member state is sued by an investor. It's the same thing in your life, in your daily life. If your neighbors, for any reasons, want to go to the court, it has the right to do it. It doesn't mean that you will win the case. So it doesn't mean, it's not because Uruguay, and I understand the issue, of course, it's a very important one, but I mean, it's not because Uruguay is sued on the basis of a BIT that Uruguay will be condemned automatically on the basis of the BIT. It's unfair from, I don't know the issue in details, but my first impression is that, well, this is quite unfair from Philip Morris. And it's concerning for us because we have that also, the warnings on the packaging here in Europe. So, but it doesn't mean the result of the arbitration.
No, but can I just add that this case almost caused a chilling effect in Uruguay, because the Uruguayan government didn't have the money to afford the legal cost. So it was about to withdraw the legislation, and only because the mayor of New York stepped in and agreed to pay the legal fees of the law firms, they decided to push through with the case and not withdraw the legislation. So it's also the fact that, you know, the way that the BIT is drafted allows the investor to even put this type of suits and cause, you know, in some cases, these chilling effects. So you don't even need to go through the whole process of an award to have, to force the government to withdraw legitimate legislation in the public interest.
Yeah, but
we're already running 26 minutes over time, and I'm sure our speakers probably have to go fairly soon, and I know that there are lots of questions here, so can we please keep the questions really short, and whatever you want to discuss otherwise, maybe you can do it bilaterally, is that all right? So over here there are a bunch of questions. Just keep them as short as you can, please.
Okay.
There you go.
My first... My first is just a quick response to the response from the European Commission to my colleague in Zimbabwe about the economic partnership agreements. The WTO did not require and does not require the European Union to include requirements for investment liberalization and services liberalization and opening up in government procurement. A Commission's own choice. But my main, and it's contentious, it was blocked in the WTO. But my main observation is, in addition to all these by the way, I'm Dot Keat, I'm from South Africa. And in addition to all the very interesting issues, very important issues that are being raised, however, the picture is an incomplete picture because financial flows from Europe are changing and are not only greenfield investment, mines and plantations and factories and so on. UNCTAD is pointing out the recent trends, and even for 2011 so far, there's an increasing emphasis on mergers and acquisitions and a shift towards portfolio investment, and very mobile portfolio investment and very volatile financial and speculative transactions. So in fact, what we are facing, what used to be called greenfield foreign direct investment is becoming a decreasing proportion of European financial flows into and, by the way, out of Africa and other countries, which are very destabilizing. And therefore, regulation is actually vitally important, as within Europe and in our countries, of these very volatile financial flows. And my concern is that while it's absolutely essential for us to study every tree and every leaf on every tree, we mustn't lose sight of the forest. And the forest is on fire, as Europe knows and as we are experiencing. So I would just say the picture is much broader than simply formal investment flows.
Good points, thank you. Yep. And then you keep them as quick, as short as possible, please.
Buenos días, soy del Salvador, Centroamérica. Yo quiero plantear dos cosas. Una tiene que ver con el tema de transparencia. Yo creo que la Unión Europea no solo debe de ser transparente ellos mismos, sino también exigirle a las contrapartes, a los gobiernos contrapartes que lo sean. En el caso de El Salvador, ya se aprobó el acuerdo de asociación con la Unión Europea y estamos a un paso de ratificarlo. Pero previo a ello, en el proceso de negociación y con la prolongación del Sistema General de Preferencias, se presionó al gobierno, pese a que es una cuestión de derecho interno, para que se ratificara el acuerdo, el convenio 87 y 98 de la OIT. Y el gobierno salvadoreño lo hizo de manera formal. Eso lo hizo en 2009. Sin embargo, no se dio el paso a la aplicación real de esos dos convenios, porque nosotros invocamos la intervención de la OIT en algunos casos en donde se viola la libertad sindical, y la OIT recomienda al gobierno salvadoreño a que reforme la legislación interna. 2 años después no lo ha hecho el gobierno salvadoreño. En tanto ello, de nada sirve de que formalmente se hayan ratificado los dos convenios 87 y 98 de la OIT si en la concreta, en la vida real, eso no ha tenido una aplicación directa. En tanto ello, yo pienso de que pese a que existen las condiciones y los estatutos establecidos taxativamente en el acuerdo, por también ser un acuerdo político, el acuerdo de asociación, la Unión Europea bien podría monitorear u obligar a los estados a que sí cumplan realmente con esas disposiciones que van en busca de garantizar el respeto de los derechos humanos. Muchas gracias.
Sí, buenos días. Mi nombre es Manuel Pérez Rocha, de la Red Mexicana de Acción Frente al Libre Comercio. Trabajo en el Instituto de Estudios Políticos de Washington, D.C. Y le quiero... Rubinachi, con todo respeto, pero me parece que la respuesta que le dio a mi colega de México demuestra mucho la hipocresía que existe en estos acuerdos de libre comercio, en específico en el acuerdo de libre comercio con México, debido a que la cláusula democrática debería garantizar los derechos humanos, incluyendo derechos políticos y civiles, como el derecho a la participación y la transparencia en estos asuntos. La cláusula democrática debería de ser vinculante, sin embargo no lo es, y se demuestra después de 10 años que no ha servido absolutamente para nada. Y la respuesta que usted dio de que depende de nuestro gobierno y de nuestra sociedad civil el que exista acceso a estas negociaciones, a la información, a los textos, pues demuestra que no hay ninguna voluntad verdadera de la Unión Europea de que las terceras partes, ¿no?, de third parties, cumplan con requisitos mínimos de transparencia hacia sus sociedades. Ese es solamente mi comentario. Solamente quiero enfatizar que dentro de esta discusión, que es muy técnica, en torno a asuntos de inversión, ¿no?, de BITs y todo esto, existe el envoltorio, ¿no?, con el que generalmente se envuelven las negociaciones europeas, que son los derechos humanos, que quedan sencillamente como un adorno. Y esto tiene que ser revelado, ¿no?, porque no puede seguirse utilizando los derechos humanos como un pretexto para realizar negociaciones comerciales en beneficio solamente de las grandes corporaciones europeas. Gracias.
Okay, we'll take you.
Yes. Hello. Hello. Yes. My question is to Mr. Rubinachi. My name is Joseph Puruganan. I'm from the Philippines, but I work for Focus on the Global South, and also I represent the EU-ASEAN FTA campaign network. There have been some discussion on India and Canada, and I feel it's necessary to have a conversation as well on Singapore and its implications on the rest of ASEAN. Mr. Rubinachi said, for example, that you enjoined us to look at the modifications of the negotiating directives together with the rest of the negotiating directives for ASEAN. In the case of the EU-Singapore, if I'm not mistaken, the mandate is for an EU-ASEAN FTA negotiations. And in that mandate, it clearly recognizes the development asymmetries that exist within ASEAN. Of course, Singapore is on top. It's a very rich and perhaps powerful country in the region. But compare that to, let's say, my country, the Philippines, there's really a big asymmetry in terms of the levels of development. I was just wondering if the mandate then the mandate on investments recognizes these asymmetries, and would it be possible then for the EU to contemplate a different approach or a different text altogether to when it negotiates bilateral agreements with this expanded investor protection provisions in the investment chapter with the rest of ASEAN member states, perhaps with more explicit language on the right to regulate, and perhaps clearer direction on the possibility of a different approach or model in terms of settling disputes, because the cost of these disputes, of really trying to face up to the challenges, is really enormous for countries like the Philippines. So there's also a differentiated level of ability in countries in ASEAN to address some of these challenges. So that's my question.
All right. As the moderator, it's my job to be the party pooper. So I'm sorry, but that was the last of the questions I'm going to allow. Maybe you can carry on talking with our very patient and excellent speakers, actually, which is, I think it's a wonderful opportunity we have to speak with them. So if I can ask you, please, both of you, to answer in quite a succinct manner, and then also give us an idea in 1 or 2 sentences, having heard all of this and having been working on this for a long, long time yourselves, where you will be focusing your attention to make this new EU investment policy the best it can be. Will it be to have some kind of monitoring system? Will it be to keep in mind the needs of your third parties? I guess the answer is no. Will it be to, will it be, you wouldn't be a good negotiator if you did. I guess it's somebody else's job, maybe. I don't know. Tell us. Will it be to do something about, to have a more formal system of arbitration and to improve on the systems that are currently in place? So if you can answer the questions and then also give us a little answer of where your focus and where your attention will be.
Okay, thank you very much. Well, at the outset, I want to stress that I knew that coming here, this would be an interesting debate. But I think this debate was even more interesting than I expected, and it clearly shows that we need to continue talking to each other. So I think this is the first big thing that I get back with me. Now, very quickly on the various questions. I fully agree with those who say that the situation is much more complex and that we have to see the situation as a whole. And this is what I said in my introductory remarks. There is one important element, is that by including clearly foreign direct investment or investment in the understanding of the Commission under the common commercial policy, we're going to be able to ensure an even greater consistency between investment policy and all the other aspects of the common commercial policy, and therefore also of all the other aspects of the EU external action, because the Treaty of Lisbon also clearly says that the common commercial policy is inscribed in the overall EU external action. So I think that this is something that we have to bear in mind very clearly. The trends are shifting. This is very interesting. Does this affect then questions on the definition of investment to be protected? What do we do with speculation? Very good question. The answer we have for the time being is that we want to cover both FDI and portfolio investment, if only because it is very difficult to distinguish between FDI and portfolio, but also because we do think that portfolio is important to be protected. Do we want to cover speculation? No. Do we think that an arbitration panel would cover speculation? We don't think so. Is it going to be easy to exclude speculation? No. But this is an issue that is there, and I think it's very important to have it. The WTO does not require international trade agreements to cover so many things, but the WTO requires that agreements liberalize essentially all trade, and when they cover services, that they cover all modes of supply and they don't exclude a priori too many things. So there are rules, but yes, it is a decision that we have taken that our agreements should be including the various facets of trade, because today trade is not just about sending cans of goods from one place to the other. Everything is related, from services to investment to public procurement and so on and so forth. Transparency, yes, transparency is important. We do have provisions in our agreements relating to transparency. Should we be transparent completely in our negotiating process? We've discussed that. We have a divergence of view between certainly Marc and myself. But we do think that it is important that there is transparency in government regulation, and that there is a possibility for the civil society to comment on the regulations which are passed. On ILO and so on, this is a difficult position for me because I'm not entirely versed in all this, but I do know that in the sustainable development chapters of our most recent FTAs, we do have a monitoring mechanism, which we think is very important. I haven't replied to the question from the Mexican colleague. This is what Pascal has said. I don't see the things the way you see them, in the sense that what we try to do is to see that the trade action is made consistent with considerations on sustainable development. We start from the point of view that trade liberalization is, on average, is overall positive, not only for us, but also for the recipient countries. But we do see that there are elements of sustainable development that we have developed over time. If you read the Korea FTA and you read the Mexico FTA, there is a big difference. And the Korea FTA is clearly much more state-of-the-art in relation to sustainable development. ASEAN. We initially wanted to negotiate with all the ASEANs. We then had to change tack and to negotiate with ASEANs individually. We are negotiating with Singapore. Today there is no firm decision to negotiate with any other ASEAN, neither the Philippines or Indonesia or Vietnam. We would plan to use the general ASEAN negotiating directives for the overall agreement, and we would plan then to request a modification of the negotiating directives for investment if we consider that investment needs to be covered. This is something that is important. We take the view that by default, now investment is part of, if you want, the trade toolbox. So like we want to cover, I don't know, services in our trade agreements, we also think that we want to cover investment. But this is a decision to be taken on a case-by-case basis. So there is no decision for the time being. Now, in terms of conclusions, what are we going to do? Well, I think, as I said, that there are elements where we think we come from a different point of view. We don't fully recognize that investment is, I don't think anybody has said that investment is actually bad. I think that we start from the point of view that investment liberalization and protection of the investment are important. They allow recipient countries to become more interesting for foreign investment. And certainly from our point of view, we do think that in Europe we need foreign investment. So that is something that is very important. We fully see that there are issues with international arbitration. We're not going to hide from that. There are elements which need to be carefully taken into account. And my own prediction, but I'm a Commission official, therefore I'm optimistic by nature, is that this will take time, but there will be an evolution. There will be an evolution, but maybe not immediately. But we don't think that because of the problems that some have identified with international arbitration, that international arbitration should not be part of our investment agreements. We do think that the possibility to resort to investor to state is important to make the investment agreements useful in attracting investment. We do see that there is an issue with policy space. There is a divergence of views. Some think that the agreements restrict unduly the policy space. We think that the language we have in our agreements allows for the sufficient policy space. The proof of the cake is in eating it. We have to see what we will come with the final results of our negotiations. And of course, we would then need to see if there is any claim that is brought. But one thing that I think is important is that in Europe, we come from a very high standard of protection of property. If you read the European Declaration on Fundamental Rights, this is there very strongly, the protection of property. So we do think that, if you want, we have less to risk in the EU than maybe others have to fear from the Charter of Fundamental Rights of the European Union. We think we have a strong system already of property protection. What are we going to do? We're going to start our negotiations. We're going to request the authorization from Council to do some other negotiations. Juliane mentioned this in relation to the North African countries, some North African countries. We have a big plan with China, which is still being examined, and which has already been the subject of specific dialogue with civil society. I think that we want to listen to points of view, and this sort of discussion is there. But as I said, our role as Commission is to find a balance between different point of views. And we are in a situation where there are extremely important economic interests at stake. There are very high expectations from member states who are relinquishing the competence clearly, because the Council conclusions in December clearly say and clearly endorse the transfer of competences. But it's clear that the member states want to see what the Commission is going to do. The Parliament wants to use its new powers, and clearly the Parliament will wait for us at the turn of the road when it has to give its consent to our agreements. We still have many things to do. We have to have the regulation on transitional measures adopted. We need to come with new legislation on the division of competences and tasks in international arbitration. We have to still think very hard about what the contents of investor-to-state dispute settlement provisions in our own agreements could look like. Yes, we want to listen to the third countries. At the end of the day, what we have to do in our negotiations is what people call a win-win situation. But you know that for the European Union, traditionally, it has been very difficult to conclude trade agreements. We're now touting Korea as a big success because Korea was the first agreement we've managed to conclude in a very long time. The WTO negotiations show also how difficult it is to conclude agreements in trade. So, you know, the road is still full of a lot of difficulties. But really, thank you very much for this debate. I think it was very useful, and I certainly look forward to continuing the discussions. Thank you.
Well, what I want to add is that on this issue, we will have to be patient, actually, because as it has been said many times today, it takes time to negotiate only free trade agreements. But and if we just limit ourselves to BITs, for instance, the investment protection, it takes a lot of time. So we have years to have an agreement first. And but it's very good, and that's what we appreciate as member states also, to have contact with civil society. But don't forget to contact the national parliaments of the member states, because this is a decision process, democratic ways to express your voice, your opinions, and to also to approach the European Parliament. As has been said, now is decision taker, sorry, with the Council. And if you can have ideas, pragmatic ideas, that takes into account also the interest of investors, because you have to admit that's a legitimate right that the investors want to invest abroad and wants a kind of protection. If you do take that into account in your suggestion, but having a balanced approach of this issue, and taking into account the right of regulate, which is also the policy space, is also very important for the member states. Read the conclusions of last year, and well, these suggestions are very welcome, because we haven't decided yet, we haven't got any proposals yet from the Commission regarding, all the articles that will, compose the chapters on investment protection, but these suggestions are welcome. But if you take only one side, you will never get somewhere, because you don't take the other interest aboard. And at the same time, don't forget that in the FTAs, you have the Sustainable Development chapter, which is quite developed. I invite you to read these agreements, for instance, with Korea. It's available on the internet. You can read it. It's very quite structured, and with the participation of the civil society. Regarding the cost for the dispute settlement arbitration, and it's a very important issue indeed. But look at the WTO. You have systems that can help financially the developing countries in order to defend their own interest in the dispute settlement at the WTO. Why not, but it has to be decided yet and defined also, why not to foresee some kind of system like this? But we are not there yet. We haven't, the Council has only given the mandate in broad lines. Listen, Commission, you have the green light to negotiate with this and this country, and with the main principles, big principles. because also this is the right of the Commission. The Commission has the right to take initiatives and to make proposals. And so, in the sense that you have, to have a common views in the common interest of all the EU member states. But so far, it hasn't been done yet. But it's normal. It takes time. And as I said, we have to learn from the experience, also from Canada, but also to see what will happen in United States, because they have a model which is more recent than many BIT model in the EU. It's the case, for instance, for Belgium. So why are they changing? And in which way? And I know that at the same time, they are looking at us to know what we are going to do. So it's very important to maintain a dialogue also, if you have contacts with also the civil society there, to exchange information and views. And regarding the approach we have, it's indeed a broad approach that we have. It's a broad picture that we have to take into account. And the conclusions, sorry to come back all the time to these conclusions, but so far it's the only official document of the Council, and which is a stance of the member states. And we work on this basis with the Commission to define this new policy, in particular on the investment protection. And that's why we are focusing on the investment protection, because something very new, but it's also very delicate. It's not easy, but be sure that we don't forget the broader picture of that, even if it's indeed not easy to come back and keep that always in mind. But be in contact with the Parliament, European Parliament too, and this is very important. This is the democratic game in the EU. The member states, I should say the Council and the European Parliament.
Great. Thank you very much. Thank you very much to our speakers. I have to say, I think of all the panels that I saw in Ireland over the weekend on the comics of the comedy of economics and the economics of comedy, I think this panel was far better. Your questions were much better. So thank you very much to Pascal and Leopoldo and Mark. And thank you to all of you for coming and your excellent questions.